Welcome back to the Thinc Conversation. With me is Miss Colette Clark, a budding scholar in public administration reform. We were still on that political administrative dichotomy. You were still sharing with us the distinctiveness of our own, because you had just said that we have juniorized ourselves. Can you come there?
Yes. What we have to understand is that our first 1910 constitution was our founding constitution.
Mm-hmm.
And the irony is the following. The institutions that are in a constitution are the same institutions that are responsible for the next big bang moment to come up with the new constitution. So you're finding that there's a serious part dependency in that the institutions who started off are still the institutions that have morphed along the way. So you would then have a part dependency in relation to the interests of the individuals who were part of the previous institutions who had legal authority to be part of processes for the subsequent constitutions. So one of the things that, remember that the 1961 constitution had made specific reference to constitutionalizing administrative authority. And therefore you then had the bureaucrats who eventually became securocrats in many instances, who firmly believed that they were a fourth arm of state. So the correction happened. Fast forward, you get to the 1993 constitution and you get the aspirational aspect in terms of the introduction of a Bill of Rights for the 34 principles that were thrashed out at the multi-party talks, which then were entrenched after constitutional endorsement into the 1996 final constitution. But therein lies the challenge, in that the final constitution makes no reference whatsoever to administrative authority, which had already been entrenched into the bureaucracy. And therefore they believed that they were a fourth arm, and they're not a fourth arm. So the sobering of the final constitution reduced us back to our three arms, which then is the judiciary, which then is the executive, which then is the legislature. Meaning that if you legally are looking at the political administrative dichotomy, we then are only looking at the relationship between the accountability of the executive to the legislature. Now where does the dynamic change? The dynamic changes when you get a coalition government. There's no such a thing as a government of national unity. That ceased to exist on the 17th of April 2008, when any notion of a GNU was then repealed by that repeal of the amendment of the Constitution on that date in 2008. And that was in the Schedule 6A, which was only a transitional arrangement for the first administration up to the 30th of April 1999. So that is extremely important in the sense that now you have in a situation.
So GNU is just a figment of a
It's a figment. It's got no constitutional
legal standing,
basis.
but it's just a figment of how people decided to convince each other. But
Yes.
let me move to this so that we don't. I want us to move to the other questions. We are going through a very consequential inquiry over policing in the country, where the minister today is actually accounting. I wish I was sitting and listening, but where again the issue is the minister issued an instruction for the disbandment of a political task team. And the national commissioner, who's written in the constitution, seems to have decided that he's not going to implement it the way the minister wants, and all hell broke loose, and we are where we are now. Now, my issue is, what are the public administration issues in this thing? Let's not get into the merits and whatever, just the public administration issues in terms of the reform space.
Yes. I mean, that's been crystallized years ago. It's about the executive authority and understanding the executive authority, which exists in the Constitution. The administrative authority doesn't exist, and it's dependent on national legislation to exist. But the important thing is that if you're following the Chicago school debates on decision making and delegations, which finds himself both in the public service space as well as in the private sector space, it's entrenched. And there are just 7 principles. And for whether you're an executive authority or whether you're the head of an administration, no matter what that functional area is, they're the same. Quickly, who has to verify the decision? What is all the intelligence in terms of the rational boundariness of how you can make the decisions? Number 2, who has to authorize that particular decision, meaning that you got the authority. The authority is either from the original legislative provision, or it was delegated to you via the executive authority. You didn't just get it. Because let's understand, don't confuse authority and power. Power is within a legislative instrument, and authority is as a result of that power that's found in a legislative instrument. The third thing you've got is the responsibility is someone who has to own the decision that's been taken, whether they have delegated or not. So who's the responsible person for that? So if a minister is responsible for policing policy, policy can only come from the legislature through a constitutionalized process.
Which is the Constitution and legislation.
And legislation.
So the legislature, regulations, then delegations.
Yes. So the legislature plays a very, very important role in determining where must that power be vested, because that would be in legislative instruments. So we've got 2 things in the Constitution. You either have got the organic and you've got the constituent sections, which are, the separate chapters, or you then have the living constitution part, which then is from the Bill of Rights. So when you get into the 4th aspect, you will find that there are certain individuals that have to be informed along the way, and hence bureaucratically you would have something called an artifact called a submission. With the submission would be a delegations register, which Cabinet had institutionalized already in 2011. That if you're going to make a decision as an executive authority and you are then going to deviate from something that was written or the power was vested somewhere else through a legislative instrument, give a valid reason why, and the valid reason then must be rational in case there's a challenge to it legally, and then you can defend why you took that particular decision. The next thing is that people have to be consulted, and normally the consultation is if the law said that the legislature had to be consulted with regards to a decision, or there were stakeholders that had to be consulted in a decision, or within the bureaucracy, either the legal section or the finance, because there were financial implications of the decision, must be consulted. They would then proffer an opinion as to whether you can do it or you can't do it in terms of consultation. Then somebody must execute it. The person who executes it is not necessarily the one who makes the decisions. So after executing, you would then get an examination of the particular decision, which can terminate it or continue with the decision, or you can get the auditing, which is the role of the Auditor General.
But Colette, we're sitting here with a situation where the executive authority has recommended a decision, and the Constitution puts a commissioner to be in charge of control and direction of the police, and you have a minister with an experience of coming from the department or from a different executive authority environment, and here you've got a head of administration who's written in the Constitution, and it seems like that is the clash. But what I want to ask you in this instance is to say, how does this play even in other spaces of public administration? Let's move away from the police to say, are there spaces where the executive authority has more expansive powers and there are spaces where it is not? Like, I mean, in the army, there's a general. In the Watwa, there are spaces where you find that somebody can say not necessarily no, but actually determines a lot than the executive authority and vice versa. Can you talk to me about that?
Yes, well, it depends on what the national legislature. The national legislature is enjoined by the executive to determine where the power lies. That's important. So there's a difference between a clause in the Constitution that is giving a nomenclature. If you're looking at the military command, for argument's sake,
Yes.
it can be numerous people. You can have a chief of the army, you can have a head of the navy, you can have the head of the Air Force, you can even have a chief of a special branch, depending on what that special branch is in that military command. And you would then find there's three things. Something is constitutional if it is prescribed and you're obliged to do it. Something is proscribed if you're prohibited from doing it. And something is permitted if it's not offending the Constitution and it's giving you elements of discretion, normally within legal instruments. So if the executive in drafting the legislative instruments goes to the legislature and they would like to see executive power vested here and not with the particular administrative role, if the legislature is agreeing, then it's not offending the Constitution if it says, under the policing section, for argument's sake, my recollection is that there are at least 4 areas where national legislation had to be enacted for various different aspects. And the importance is, when you're looking at, when the Constitution is talking about it must function and be structured according to national legislation, it leaves a lot of discretion to how the legislature is enjoined to determine where that original power needs to be vested in order for someone to derive the authority. So you can't just say by virtue of your nomenclature title, I automatically have that power. You got to prove which national legal instrument conferred you with that power to claim that authority.
Oh, thank you for the conversation, Colette, for making it here. That brings us to the end of this edition. We are facing interesting public administration times as a country. The Constitution, which is the supreme law of the land, creates only 3 authorities: legislative, executive, and judicial. There is no administrative authority in the Constitution. Any administrative authority we have is either prescribed in legislation from the legislature or delegated by the executive authority. The moment we are facing as a country requires us to understand what this means for democracy. This is Lucky Mathebula from the Thinc Foundation and in the Thinc Conversation, which is happening on Business Day TV. Thank you.